The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thanks. Be seated. Happy to hear in our first case, 19-7368, United States versus Reed. Counsel, we're happy to hear from you.
Is it okay to remove the mask?
Absolutely.
Good morning, and may it please the court. My name is Maya Eckstein with Hunton Andrews Kurth, representing Larry Reed pro bono. Your Honors, there are two independent reasons under which this court may vacate the district court's denial of Mr. Reed's First Step Act motion. Number one, Mr. Reed's sentence exceeds the statutory maximum made retroactive by the First Step Act, and thus, under this court's decision in Collington, was an abuse of discretion. And number two, even if that holding in Collington was no longer good law, and we believe that it is, the ruling was not substantively and procedurally reasonable. I'd like to address each of these in turn. First, Mr. Reed's sentence exceeds the statutory maximum set forth by the Fair Sentencing Act. This court made clear in Collington that the First Step Act makes the Fair Sentencing Act's reduced statutory minimums and maximums retroactive.
Can you pause 1 second for me? Madam Clerk, we don't have a clock running.
I'm sorry.
Which, happy to give you all the time you need, but at some point we want to know how long we've given you.
I'm sorry.
No, thank you very much. Sorry, please go ahead.
Ma'am, assume, and I don't believe Collington was abrogated for obvious reasons, but assume that it was toned down by Concepcion. Just how much explanation must the district court provide for its decision?
In terms of the explanation that must be provided for its decision, this court, I believe in United States versus Martin, explained what that standard is, helped by the Chavez Mesa case of the United States Supreme Court. In Martin, that was a case involving two consolidated cases for appeal with 3582C2 motions for sentence modifications, so much more constrained analysis on the motion for a sentence reduction than is available here under 3582C1B in the First Step Act. And in that case, what the court held was, well, in that case, Ms. Martin specifically, she had had a lengthy prison sentence and a lengthy, I think this court referred to it as a mountain of evidence of post-sentencing rehabilitation. And the district court, simply said, I analyzed the 3553A factors, and I think that her offense conduct outweighs everything else. This court held that based on the complexity of that case, the length of her incarceration and the mountain of evidence that she had submitted, more was required. More of an individualized explanation was required. That is similar to exactly the same thing that happened here with Mr. Reed, but of course under the 3582C1B standard, not 3582C2. Here, the district court, I think it said about 3 or 4 words about the, again, mountain of post-sentencing rehabilitation evidence that he had submitted to the district court. He submitted evidence. I think he took virtually every program available, completed every program available in the prison system. He's been incarcerated for 25 years, since 1997.
Can I turn you back for a second to what I think was the first argument you were making about the statutory maximum?
Yes.
And when I look at the First Step Act Amendment application worksheet, and I'm at 257 in the JA, the probation officer continued to treat count 1 as a 10 to life offense. We've been talking about it in the briefs. It seems to talk about it as if it's a 5 to 40 offense. But the probation officer calculated it as 10 to life. And so when the district court imposed the sentence on count 1, it wouldn't have been above the statutory maximum, at least as described here. And I haven't seen that argument been made by you or your client. And so it seems a little odd for us to fault the district court for relying on the 10 to life sentence that's identified here in a scenario where nobody's argued that that calculation was incorrect? Start there. I've got a couple follow-ups, but do you understand what I'm getting at? So Collington, to the extent Collington, this part of Collington survives Concepcion, and we can talk about that. But at least under Collington itself, you must reduce the sentence to the statutory maximum. But here, count one is identified as a statutory maximum of life.
So, two things. Below, and I believe on appeal, and I apologize if we made a mistake on that, but on appeal and below, the argument for count one was actually 0 to 20 years. It's the new statutory maximum. Mr. Reed made that argument below because the jury was not asked to make a specific finding on drug weight. And so below and on appeal, the argument is that 0 to 20 is actually the maximum. As to counts 8 and 9.
All right, but assume I reject that argument, and instead I look at count one as it was charged, right, which was the 28 grams, right, which then means that it's a 5 to 40 offense.
Yes.
I understand the argument, but bracket that for a minute because maybe that one's not as compelling as this one. But still, we've got a scenario where it strikes me that it's either 5 to 40 or 10 to life. Probation identifies it as 10 to life, and the district court imposes a sentence of life, or doesn't impose any sentence, chooses not to exercise its discretion.
The district court actually agreed with Mr. Reed that the sentence on count one should not be a life sentence, but it was actually, I believe the district court decided it was a 5 to 40 year, and that's at JA 144 of his opinion, of the district court's opinion. But when the district
So it recognized, all right, so then help me understand why that's right, given your client's distribution of cocaine offense from 92? I'm just trying to understand the framework. I know we got lots of legal issues, but I don't understand, if I'm looking at J223, he's got a prior cocaine distribution offense that he got a 10-year sentence on. And so why wouldn't that be a qualifying prior drug offense, which would obviously change the 5 to 40 to 10 to life? So I sort of thought that maybe he got that wrong, that it actually is a 10 to life offense. Am I missing something there?
Yes, so the jury did not make a finding as to drug type or quantity involving count one. The court attributed the 2.7 kilograms to Mr. Reed, not the jury. So that decision was not made.
Right, but if that argument's right, it's not 5 to 40, it's 0 to 20, right? So if we accept the district court's finding that it's 5 to 40, he's rejected your argument that there's no drug weights at issue, right? And he's instead applying, as I think Concepcion tells us, only the changes that happen as a result of the First Step Act, right? That's the language of Concepcion. And so that change would be, if it was a no prior offense, B1B offense, then it's 5 to 40. But if there's a one prior offense, i.e. a distribution of cocaine, the B1B offense goes from 5 to 40 to 10 to life.
Your Honor, I'll admit that issue was not raised before, and I would have to look into it to address it further.
Okay. All right. We'll hear Mr. Cook's views.
Okay. Well, and I will say that Mr. Cook advised me before the argument started, and he can tell you that he believes that we preserved the statutory maximum argument. And
You did. You preserved the argument that you were making, which is they failed to raise or present to the jury the drug weights, right? That argument you preserved. I get that, but that gets you to 0 to 20. That doesn't get you to 5 to 40, because 5 to 40 requires a drug weight finding, right? It requires more than 28 grams of crack. And so once you get to 5 to 40, that argument has been rejected. There's a second argument, right, about if we're in B1B, not B1C land, what is the appropriate statutory maximum? And I'm not trying to catch you off guard. This isn't a quiz. I just wanted to know if you had a view on it.
And I apologize. Like I said, it wasn't raised below, and I haven't looked into that, but I'd be happy to.
So I totally get that, and that was sort of my concern because it wasn't raised below. Help me understand the argument that you began with then, that is you're required to reduce, a district court is required under the First Step Act to reduce the sentence to the statutory maximum. But when I look at 257 of the JA, the statutory maximum identified was 10 to life. The district court reduced that to 5 to 40. But that doesn't account for the two 924C offenses, which both have statutory maximums of life.
Well, and I would disagree with that, Your Honor. With respect to the 924C offenses, the life sentence would apply if Mr. Reed was deemed a career offender under 4B 1.1. He was not.
No, not a guideline life sentence, but a statutory maximum. So 924C, the statutory maximum for 924C, not the statutory minimum, but the maximum for 924C is life.
These were Mr. Reed's first 924C convictions.
Totally fair.
And under the statute, he was, and the stacking that applied at that time,
Yep.
he was given sentences of 5 years and then the additional 20 years consecutive. I believe that was the max that he was eligible for at that time.
Okay. Assume hypothetically that that's just not what the law is. Both the Fourth Circuit and the Supreme Court have both said that there's no statutory maximum for a 924C. Just accept that as a hypothetical. Then in that scenario, wouldn't we then have the same situation where now the statutory maximum available to the judge was, 2 life sentences plus 300 years, right? We treat counts together. And so the court there, given the 3 5 to 40 offenses and the 9 0 to 20 offenses, the court could have, if the First Step Act was applicable, imposed 2 life sentences plus 300 years. I'm not saying the court should have done that, right? That's a judgment, but that would have been within the court's statutory authority.
If the precedent for that is what you're saying.
No, it's a hypothetical.
Yes. Certainly, the district court would have had the discretion to do that, but the district court needs to have taken into account the 3553A factors, including
Okay.
sentencing disparities.
Totally fair. I get that. So, but that's a separate argument, right? So that's the argument that he didn't adequately explain or consider his discretion. It's not the argument under Collington that the district court has no discretion where the sentence was above the maximum available. And here, the maximum available pre-First Step Act was really long, but sort of under the First Step Act, the statutory maximum that was available was 2 life sentences plus 300 years.
I hear you. I'm not sure we agree that that was the maximum available.
Well,
In fact, we
accepting
don't-
my hypothetical that 924C has no statutory maximum.
Right.
Okay. And then we're back to I think Judge Floyd's question, which is the explanation good enough?
Right.
Okay. I'm sorry, Judge.
No, sorry. I was going to follow up there.
So with respect to Collington and Concepcion, we do believe that Collington's holding remains good law. Collington largely addressed 2 issues: the retroactive effect of the Fair Sentencing Act reduced statutory ranges, particularly the statutory maximum on the First Step Act, and number 2, whether a district court must consider certain intervening changes in the law or fact when determining the proper sentence.
So counsel, on that, I kind of anticipate and to an extent understand that the precise issue in Concepcion was not a statutory maximum. That's not what they were talking about. But doesn't the language in the opinion, if not specifically abrogating the Collington holding, particularly the language that says, 404C only underscores that a district court is not required to modify a sentence for any reason. I mean, the facts may not be the exact same, but how does that not just tell us what the rest of the opinion seems to imply, that, you must consider these things, but you don't have to?
I understand, Your Honor. So that statement by Justice Sotomayor has to be taken into context of what the question they were addressing was. And Justice Sotomayor states in her opinion, she specifies what the question is, and she states the question is whether a district court adjudicating a motion under the First Step Act may consider other intervening changes of law, such as the sentencing guidelines or changes of facts, such as behavior in prison and adjudicating a First Step Back motion. So Concepcion addressed other intervening changes of law, not the intervening changes of law that are actually set forth in the First Step Act itself.
I mean, I'm not really disagreeing with that. I think that is fair, but the court goes, really at almost every turn, talking about the discretion the district court has. And while that's, maybe the precise issue, it's just kind of hard for me to look at and read this opinion and not saying you must consider them, but you don't have to apply them. And that language I cite, is not constrained in any way, is it?
We believe the analysis would be different if the court had looked at the language of the First Step Act itself and determined whether it was retroactive as opposed to other intervening changes in the law. This court has recognized, and Concepcion recognized, that the very purpose of the First Step Act is to apply the Fair Sentencing Act's reduced statutory ranges. This court has repeatedly emphasized that Section 404 gives retroactive effect to the new statutory maximums. Did that in Collington, but also in Worsing and Woodson. And if you couple that purpose with the reasoning of this court, also recognized by Concepcion, that resentencing under the First Step Act is a fulsome enterprise, not a plenary resentencing, but certainly far more than under 3582 CT, and the conclusion that analysis is likely to be very different. And I would also remind the court does not need reminded of this, but of course, an opinion of a previous panel of this court is binding on subsequent panels. So hopefully that answers.
Unless the premise is undermined by the Supreme Court, right? That's the question that we're trying to get at. We all agree that if Concepcion doesn't exist, that Collington is wholly binding. But the question is, whether the statements that that the First Step Act does not compel the district court to reduce for anything, right? It seems like to me that language is hard to get around. The DDC and the White decision, the district court there recognized in looking at our prior decision in Collington that Concepcion overruled that concept of the requirement that you reduce at a statutory maximum. Is any court suggested that Concepcion does not overrule that part of Collington? Not all of Collington. I'm not suggesting that, but the narrow piece of Collington that the district court must reduce a sentence to the statutory maximum?
The only case law that we have found that squarely addresses Collington's holding about the statutory maximums and the effect of Concepcion is the White case. So we're not aware of any other case.
Assume Judge Richardson is right about you don't have to reduce the sentence. That would not change the outcome of whether or not the judge gave any kind of explanation for why he didn't consider, in particular, the rehabilitation, would it?
No, that's absolutely correct, Judge Floyd. We believe that the sentence was not, the decision was not substantively and procedurally reasonable because the district court did not give adequate consideration to the 3553A factors and really relied solely on the original offense conduct.
Is your argument concerning substantive and procedural unreasonableness? I just want to make sure I understand the aspects of it. I get the argument that it was not adequately explained. Do you have any other arguments about substantive or procedural unreasonableness besides that?
Well, yes. So a couple of things. The district court did not consider Mr. Reed's non-frivolous arguments about 924C. Now, it did acknowledge that it could consider those arguments, but once it decided to retain the life sentence, it didn't then address it further.
In the disposition part, there was no discussion of it. So that's not just the inadequate, you say 924C wasn't, other than mentioned it earlier, and wasn't explained at all?
Correct. That's right, Your Honor.
So the rehab and the 924C explanations, those are the two issues?
The rehab, the 924C issue, and then the substance of the explanation itself under Martin, the extent of that explanation because of the complexity of the case. And I see that, I believe my time is up.
Thank you so much, counsel. We'll hear from you a little bit on reply. Mr. Cook, we're happy to hear from you. Can you start by explaining to me what the statutory maximum actually is under count one? When I look at J 144, I don't see the court as making a ruling about what the statutory maximum is. That's addressing the argument that we ought to use the 2.7 kilos instead of the indictment provision. Can you help me sort through that?
So let me give you initially a little bit of history.
Sure.
So initially, the Department of Justice's position was that whether something was a covered offense or not, and this is 404A we're talking about, would require a court to look at drug quantity. And since the drug quantity in this case ultimately far exceeds the new 280 grams, the position was that it's not a covered offense. We now know, in light of the Supreme Court's opinion in Terry, that what you look to is the statute at issue in deciding whether there's a covered offense or not, and a B1A weight 846 conspiracy would be a covered offense. So that's answered. Now, what that doesn't do is it doesn't tell you the answer to what happens next when you have a covered offense. And the ruling from Collington is that you would necessarily have to lower the statutory penalty range. And it's not entirely clear what Collington meant by that in a context where the drug quantity far exceeds the maximum, whether you just never take that into account. And that would be inconsistent with what you would do, say, with an omitted element on direct appeal. You would look whether there was
But
overwhelming.
I would have presumed that we would look under Collington, I mean, maybe this is a presumption, which is always dangerous, but I would presume we would look to the indictment to see what would then, where it would then be treated as a first step. So if this was a 28-gram case, because that was what he was indicted for, the sentence under the First Step Act for that would move him sentencing-wise, not conviction, but sentencing-wise to the B1B range.
There is unquestionably a lot of lower court opinions that refer to looking to the indictment. I actually think that's not the correct way to do the analysis for either 404A or B and C. And the reason for that is pretty simple. I think that if, for whatever reason, and there are districts that would routinely charge the actual amount in the indictment, even pre-Apprendi, that practice would not render those offenses not covered offenses. So let's suppose the indictment said, 2 kilograms of crack in it. It just happened to say that back, in 1998. That wouldn't render that offense not a covered offense. It would be relevant if you were on direct appeal and you said there was an error about how you had determined the triggering drug quantity.
Totally fair, but that would be the question of whether it's a covered offense, right? Because the covered offense is only, is this a B1A offense?
Right.
Period. And so if you're under B1A, it doesn't matter what the number is for A. That doesn't necessarily translate for B or C.
Right, and here's how I think the analysis works now, in light of the combination, really, of Terry and Concepcion. First, you have the statutory focused inquiry about whether there's a covered offense. Then you ask, am I going to reduce the sentence? And we know that the structure, the reasoning of Concepcion, I think, is inconsistent with Terry. And let me explain that. So Concepcion says, analytically, what we're going to do here is the language of 404 controls, and then there aren't these limitations otherwise that exist that are not in the statute, and we'll look to background principles of sentencing law to fill in. And when you do that, there's nothing that can overcome 404C's very clear language. And I would say there were some things about 404 that are sort of hard to figure out. But 404C is not hard to figure out. I mean, it says nothing in this section shall be construed to require a court to reduce any sentence pursuant to this section. And there is nothing in Concepcion that leaves you with the tools to say that that doesn't mean what it says. Furthermore, you have now this growing body of precedent that recognizes that 404 is purely a sentence reduction statute. It doesn't change the classification of an offense. And so, since it's not changing the classification of the offense, it's incorrect to say that the statutory penalty range has in fact been knocked down. It's just saying, look, in the exercise of your discretion, you can reduce the sentence, and you should take into account how the Fair Sentencing Act would apply. But it is not saying that your criminal liability has changed. It is not saying that the statutory maximum has in fact changed, and that explains why 404C makes sense, that it says nothing in the section shall be construed to require a court to reduce any sentence. And that makes sense because it's a discretionary sentence reduction.
So help me understand how that theory would apply. So in that scenario, as Concepcion and others tell us, we have to figure out what the new guideline range is.
Right.
And in doing that, part of the guideline calculation includes what the statutory maximums are, right? Because that informs both in the career offender context, but also in the drug context, what the actual guideline sentence is, right? It sort of caps it or raises the floor depending on whether it's a maximum or minimum.
Right.
So you're required to calculate what the new statutory maximums are in order to do the revised guideline calculation. Fair? Are you with me so far?
I am, with a qualification, and I would point the court to page 2402 of the Supreme Court's opinion. And it says, and I'll read the passage, thus, the language Congress enacted in the First Step Act specifically requires district courts to apply the legal changes in the Fair Sentencing Act when calculating the guidelines if they choose to modify a sentence. And so I think that last language, if they choose to modify a sentence, means something. And what it means is if you're choosing not to modify the sentence, then
You don't need to calculate the guidelines at all.
yeah. I mean, now, if a defendant rolls in, there's other parts to Concepcion that says, if the defendant says, I got a covered offense, and there were errors, and I'd like you to consider them, the judge has to address those arguments and take them into account. But if the judge is like, what happened here?
Okay, I understand that argument. I think that's helpful. But bracket that, assume that the district court does recalculate the guidelines or is going to reduce. In order to do that, he has to figure out what the statutory maximums are, because that determines, in some instances, what the guidelines are.
Right.
Not necessarily in this case, but in some.
Yeah, career offender case, the statutory maximums that would apply would directly affect
What the guidelines are. In other contexts, where there's a max, the guidelines become whatever the max is. But in that scenario, what would they then look to determine when you've got an indictment that was 28 grams of crack? How, would they in that instance look to the indictment to determine what the statutory maximum is? You see what I'm saying?
Sure.
In this scenario, we've narrowed it down to a smaller spot. But in that scenario, would you have them look to the indictment, or would you have them look somewhere else to determine what the statutory maximum would have been under the First Step Act? It seems like to me that's got to be the indictment.
I don't think I would agree because, for example, you could have a case that is indicted pre-apprendi where the drug quantity was not mentioned in the indictment. And the lack of a drug quantity, I do not think would zero you out to a 20-year max. I think a district judge would have discretion to say, look, there was...
tons of discretion, right?
Yeah. Right.
Except we've got discretion, but assume we got to do the guidelines. I mean, so in the pre-apprendi, like old world, if we go far enough back, they include no drug weight. What would you have the district court look to identify the statutory maximum, if not the indictment?
I think that the evidence in the case would be, so there are going to be cases that were 50.
So here, the 2.7, you'd say,
right,
we ought to figure the
right. I think that's right. I mean, there are going to be cases where there was a defendant stopped in the midst of a drug sale, and the drug sale was, 57 grams of crack. And you can look at that case and you can say, there's no question that applying the Fair Sentencing Act, it would not be a 280-gram case. But there's nothing, let me put this more broadly and practically. There's nothing in the language of 404, A, B, or C that compels a court to grant windfalls, where you can look back at the case and say, this was a massive 12-year conspiracy, and
Didn't we sort of didn't the court sort of get away with that, get away from that idea when we applied and the Supreme Court applied, Apprendi to drug weights, right? I mean, what the court said there is, well, you look back to the indictment, right?
There's still, in light of cases like Cotton, clearly a harmlessness inquiry, and Greer is another illustration of that, such that even when you're talking about omitted elements of the offense, you can say that the omission is harmless. And what's more is that whole body of law, it stands apart from the First Step Act as well. And so I think it's a fair, and really I would read the district court opinion in White from District of Columbia to be saying this, is that these Apprendi rules are in a class with the ones that the judge may consider but doesn't have to, such that, Concepcion says, look, when you go to exercise your discretion under 404B, you can consider these other arguments, and Apprendi-type arguments would be one of them. But you are not compelled to take hear a 2.7 kilogram case and say, really, we'll treat it like it is not even 280 grams. And the easiest way to see that is just to follow the structure of 404, which is first you ask, is it a covered offense? That's answered not by facts, but by looking at the statute at issue and whether the defendant's got a B1A, for example, conviction. Here, B1A via 846. Yes, it's a covered offense. You don't need to know more. And then the rest of the statute says, exercise your discretion and address the defendant's arguments. And it is, nothing requires you to reduce any sentence. And the defendant is free to make arguments that would say, really, the drug quantity is such that I should get a reduction. Or never mind the drug quantity.
I just want to make sure I understand this, because it strikes me, what Concepcion tells us is that you must, at least if you're going to reduce the sentence, I understand that argument, but bracket that for a minute, that you must recalibrate the guidelines to reflect the Fair Sentencing Act's retroactive application. And the question is, application to what? And I think we would all say that if you indicted somebody today and said that they had 28 grams of crack, they would fall in the sentencing range of B1B, right? And so if the Fair Sentencing Act applied to the facts, to the retroactive application of the facts then the indictment would determine the statutory maximum, not the actual drug weight, right? That's what we would do that today. If you had a case that said 28 grams in the indictment, and then you prove at trial that it's, 2.7 kilos, you give the jury the question, is it 2.7 kilos? They find it's 2.7 kilos, the judge finds it's 2.7 kilos, but the indictment says 28 grams, we're B1B, we're not B1A, right?
No, I would resist that. Let's take a case that's charged today, so no question the change from the Fair Sentencing Act applies. The indictment, there's a mistake. It says...
Left a zero off.
Yeah, left a zero off. It says 28 grams. All the evidence at trial is this was multi-kilo transactions with the Colombians. And then on appeal, the defendant says, look, you had to treat this as a 5 to 40 case because look at the indictment. That could be subject to harmlessness. Cases like Cotton and Greer, I think, establish that.
Right, so totally fair, right? I totally get the harmless argument, right?
Yeah.
But what we're told is that we're to recalibrate the guidelines to reflect the Fair Sentencing Act's retroactive application, not the meaningful application, right? It just means do it right? That doesn't seem hard, right? Not do it in a manner that's would survive plain error review, but do it right. Like, take the Fair Sentencing Act, take the facts of our case, which includes the indictment, and apply the Fair Sentencing Act's description to our facts, which is indictment of 28, proof of 2.7, and say, all right, that's the calculation. Now, then the district judge says, okay, well, I think that's not right, and I don't care about that because this guy's really terrible or this guy's really great, and he applies his discretion. But I guess I'm having a hard time getting past to figure that out if we're doing the guidelines, that we don't look to the indictment to determine the statutory maximum.
Right. Well, and it may be that, I mean, I don't agree with that, but the distinction may be one that doesn't make much difference. If you agree that ultimately the judge doesn't have to reduce any sentence, then whether you look to the indictment or not becomes not terribly significant, because the judge would then be looking to.
Yeah, but that's consequences. I don't care about the consequences of what we do, right? I'm trying to figure out the right way to do it. And it's hard for me to see that I look to the actual conduct in this case when there's no scenario where I look to the actual conduct in these statutory maximum cases today or really
Right.
since Apprendi.
Well, but I would say there's literally nothing in any subsection of 404 that says look to the indictment. And if you
No, but it
establish
says
Says
apply.
Yeah, and then the court says you must, again, whether the reduction clause you talk about in Concepcion applies, but it does talk about the requirement, I think, to recalculate the guidelines. And when you look at the footnote that follows that language, that makes it more clear. It may be debatable given the language you mentioned, and so it seems to me you have it's suggesting a recalculation, even if that doesn't require the application of a new statutory max. That's a separate question, but a first step seems, no pun intended, a first step seems to
Right.
be, let's recalculate it as if, and then decide what to do.
Right. Well, and I don't want to belabor this point because I think that from the government's perspective, what matters here is that you not end up with windfalls that, in a case like this that's got huge drug quantity over 12 years, 2 murders that the defendant's held accountable for, that there isn't just some sort of automatic reduction in sentence. And so if, as an administrative matter, you have to say that the statutory maximum.
Well, the windfall, to some extent, is of your own making, right? I mean, you indict how you indict, and I get the strategies and all that, but to the extent there's a windfall, the government has some role in that, doesn't it?
Well, I mean, that would be to say that the government should have, in the 90s, anticipated that Congress
Fair.
would pick 280 grams.
Yeah, that's fair.
And there's no way to know that. And indeed, that might change again. But I hear you. I mean, I don't want to, in any sense, belittle, because I shouldn't and couldn't, the importance of the grand jury process and getting an indictment returned. It's that we are asking that inquiry here in the context of a discretionary sentence reduction. And I think that what happened in the indictment process is really kind of a lot less material than a lot of other facts about what the appropriate way to handle a sentence reduction is here. Like what matters from the sentence reduction standpoint is the gravity of the conduct and how you're going to treat different defendants. And the
Can you turn just for a second and talk a little bit about the sort of alternative argument that, all right, full discretion, you can do what you want to do, but we got to have more about rehab, 924C, and the sort of explanation for why that discretion is exercised?
Right. Let me start with what I take to be kind of the more complex question, which is the 924C. And on that point, the district court adopted the view that it had the ability to lower those sentences. I don't think that's actually accurate for the following reason. So there's two 924Cs, and the then applicable mandatory minimums apply. Under this court's opinion in Gravatt, you don't get to revisit mandatory minimums that are unrelated to the Fair Sentencing Act, and these are unrelated to the Fair Sentencing Act. Now, the question becomes, and this is, in fairness to the defendant, the defendant's point is, sure, but Congress eliminated the stacking penalties, and so you should apply that now. But the reason why that doesn't work is, in a nutshell, this court's opinion in Jordan, which is, Jordan says, look, was a sentence imposed for that? And yes, it was. And so the 403 change to the 924C penalties has no application. And so the district judge really was obliged to leave those 924C sentences unchanged. Now, I don't think this court ultimately has to get to that question, because this district judge thought he could do it and was like, no, I'm not doing it. And the reason is, I think, fairly understood from the opinion, which is there was a lot of drugs, this was a long conspiracy, and you committed 2 murders. And so that's a fair reason to be like, I'm not going to change the sentence. And what's more is as to the 924Cs, even collectively, the sentence falls within one 924C's penalty range. So he was certainly within his rights as a discretionary matter. Now,
I'm sorry.
So, I mean, I hear you. I think that you could read the whole opinion and
Right.
and certainly say that's what the district court was talking about with respect to 924C. And if we were, maybe talking with a clean slate, that might be the case. But, given our precedent, do you really think the 924C discussion, predisposition, is enough to meet what we've talked about in other cases?
I do. I mean, look, the Supreme Court, obviously this court has expected a fair amount in the way of explanations. It is also the case that in Concepcion itself, the Supreme Court reaffirmed its view that a brief statement of reasons suffices and that a court is not required to expressly rebut each argument. And in context in this case, I think it is important to remember there was not a dispute about the guidelines in the district court, other than this, what's the applicable statutory maximum on the counts. And the essence of it was the defendant said, I've done a bunch of things in prison, take courses, been on the suicide watch program. And on the other side of the scale was a defendant who participated in a leadership type role in a very long-running conspiracy and committed 2 murders.
I mean, that's kind of getting to the, was it justified?
Right, but
talking about a little bit, slightly different question, at least, as to whether, at least in the 924 context, that was,
right.
enough.
My point is just, I don't think at the end of the day this was terribly complicated. The judge was looking at it and was saying to himself, you are a very dangerous offender. You committed grievously bad crimes. And the defendant is saying, but I did some stuff in prison that is good. And he said yes, and he enumerated those, but that just doesn't outweigh the fact that you had this gravity of crime. And I do think that informed the judge's view and explained what he was doing with the 924Cs. Now, if his reasoning had been something closer to what the government is saying here is the right answer, that, sorry, I can't apply, 403's changes to the 924C penalties, I would expect to see more, because he didn't have that reasoning, and that wasn't his reasoning. So I'm offering that as an alternative basis to affirm, is that, sorry, you actually didn't have the discretion you thought you did.
Well, we've had academic argument about 403, but isn't it just as simple that he was actually sentenced before the enactment of Section 403?
Yes.
Now, if he committed a crime and 403 was passed, then he would get the benefit.
Yes,
So,
that's right.
so in this case, it's not going to help him.
Yeah, I agree with that. It's really not that complicated.
Can I ask just one final question?
Sure.
If you accept that you look to the Fair Sentencing Act and the indictment to determine the statutory maximum, then was it an error? If that's right, I understand. Was it an error when the probation officer said count one was a 10 to life offense?
No, and Your Honor is right. Paragraph 128 shows the defendant had a prior felony drug offense, and so that would have triggered, even on the assumption that it was a 28-gram case, would have triggered the 10 to life range. Now, having said that.
That might be right, but nobody made that argument.
That is true.
And in the original PSR, they didn't rely on that distribution offense. I'm not sure what, probably because it wasn't all that important given the length of sentence he was otherwise going to get. But wouldn't that also then mean that counts 8 and 9, which are also 28-gram offenses, should have been 10 to life, and they figured those as being 5 to 40? I mean, there just seems to be some inconsistency.
Right. No,
Eight and 9 and 1 they have to be the same.
that's Your Honor is right. And in fairness, nobody paid any attention to this point because it didn't matter. You know, everyone said, look, by drug quantity alone, these offenses have the penalty range that they do. And so it wasn't necessary to do an analysis about the prior felony drug offense. But it's there, and that is going to trigger the penalty range. I mean, similarly, if this court were to say that you had to lower the statutory maximums under the Fair Sentencing Act, then the guidelines would say, because the guideline range is life, that you would have to stack counts. And this court's en banc opinion in Engel, not long after Apprendi, was an illustration of that. And I've cited that in the supplemental brief, as well as recent unpublished case that I cited, Hines and Allen and Chase, is that you would have had to stack. Now, having said that, in this case, the judgment of conviction and the way the sentences are configured doesn't reflect that that's what happened. So you'd either have to say that the failure to do that is...
But you could, the point is that you could, in this instance, impose 2 life sentences plus 300 years based on stacking.
Right.
And that's the same effective sentence that was imposed before.
Correct.
Unless there are other questions? Thank you, Mr. Cook. Counsel, we're happy to hear from you.
Thank you, Your Honor. Just a couple points. There are a couple of ways that we believe that this court can decide to vacate and remand here. Possibly the cleanest way to do that, based on the discussion that we've had here today, is really on the basis of substantive and procedural reasonableness. I would like to add, to make sure the court is aware, that in his 25 years in prison, Mr. Reed has been employed by the prison system throughout that 25 years. He has received only 2 infractions in that time period, the last almost 20 years ago in 2003. As explained in Martin, this is a far more complex case than the district court made it out to be. It required
What would you require a district court to do after Concepcion, right? Concepcion seems to say that, a brief statement that's all required. You don't have to rebut every argument that's made. And here, the district court acknowledges the rehab, right, and gives a brief statement, right? Under some of our prior precedent, I totally understand the argument. Help me understand, after Concepcion, like how that doesn't mean that this is enough.
Even Concepcion doesn't disregard the idea that complex cases require maybe a little bit more, something a little bit more.
Right, but okay, so then, all right, and so why is this case complex, right? I mean, he commits 2 murders, he's got drug weight that's over the life requirement. He's engaged in, like, not just actual violence, but he's carrying guns around. I mean, this doesn't strike me as the most complex case.
Add to that a couple of things, Your Honor. Add to that 25 years of imprisonment. Add the fact that I believe that all of his co-defendants have already been released on First Step Act relief, for the most part, is my understanding. The sentencing disparity issue. Add his conduct in prison over those 25 years and the mountain of post-sentencing rehabilitation evidence that he has presented. In addition, With respect to the drug weight, I think that the answer is that you look to the indictment, but you also have to look to see at what the jury found. The jury here did not find 2.7 kilograms of crack. The indictment was the indictment, but the jury was not asked to make a specific jury finding. And you cannot, as this court knows, we cannot increase the statutory maximum based on findings that are not made beyond a reasonable doubt. So with respect to that issue, because of those holdings, we don't think that he was, because of those holdings, we don't think that he was subject to the life sentence under that count one. And as a result, Your Honor, we would ask that you vacate and remand Mr. Reed's sentence.
Thank you, counsel. As you probably well know, we have a tradition that we very much enjoy of coming down and greeting counsel. We have not yet restarted that condition given where we are, but we certainly thank you both for your arguments, and we look forward to having you back where we can greet you in person. We'll move to the next case, 2120 Resendez versus Exxon Mobil Corporation. Counsel?
Good morning. May it please the court, my name is Thomas Sines, and I represent the plaintiff appellant in this case, Aldo de Leon. As you know, Mr. de Leon is a young immigrant to the United States who has received work authorization through being granted deferred action for childhood arrivals. About 3 years ago, he was pursuing his American dream by attending North Carolina State University and seeking a degree in chemical engineering. During his period of time as a student, he was recruited by the defendant Exxon Mobil to apply for an internship, a limited term internship of about 3 months in duration. He did that.
Were there requirements to be a part of that internship? What was the internship for? What group of people?
It was for students who were engineering students, I believe, Your Honor. It was a general application, though ultimately he was asked to file a separate application for a specific Exxon Mobil location. But the important point is, I believe there were locations throughout the country for which the internship that he initially applied for could be served.
Sir, let me ask you this. Exxon hired him, and at the time, they knew he was not an American citizen. And then they rescinded his employment when they found out that he only had a temporary work authorization. How could you possibly accuse the company of discriminating on the basis of citizenship?
Your Honor, this is the crux of the case, as you know. This is a circumstance where discrimination on a prohibited basis is being practiced against a subgroup of that entire protected class. It happens in other cases, has been recognized by the U.S. Supreme Court as recently as the Bostock decision, that the fact that you hire others within the protected class does not mean you are not potentially violating a prohibition on discrimination against that class. In this case, it would be alienage at the basis for discrimination, and though ExxonMobil does hire some who are not U.S. citizens, we still contend and believe the briefing, the complaint, demonstrated sufficient to get by the motion to dismiss granted by the district court, that this was discrimination on the basis of non-citizenship, even though the company did hire other non-citizens.
So, counsel, just to talk about the Bostock case, I hope I pronounce it right, but to follow up on Judge Floyd's question, the basis of the decision there seems to be the connection between sexual orientation and transgender status on the one hand and sex on the other. And it's pretty clear to me that in that opinion and the way the statute's written, that can't be as a result of a kind of factual consequence, like a disparate impact situation. It's got to be intentional. There's got to be a intent element to it. And the way the majority opinion is written, with several of the hypotheticals, it seems to focus on, for example, an individual who has an affection towards men. And then to decide whether that's discriminatory, you need more information. Because if it's a man, you need that information to determine whether there's actual discrimination or not. And that there's a couple other examples that fall that way. Here, it doesn't seem like that's necessary. The knowledge about the work status is all you need to know to determine whether or not this Mr. De Leon was within the classification. It may be true, and you're certainly right, that factually everyone who has that will be a non-citizen. But you don't need that to complete the picture. And that seems to be the way Bostock ties those two issues together, is sexual orientation and sex. And I just don't see how we have that here other than in a disparate impact sort of sense. Can you address that? Maybe I'm reading that wrong, but, and I get there's parts of Bostock that are, I don't get how that every part of it matches up, but that seems to be the fundamental linkage of those two issues.
Well, what Bostock tells us is that you have to look at the description of why the person was discriminated. The person was gay, lesbian, transgender, and then compare, using a but-for analysis as the court did in Bostock, to determine if a similar discrimination, if you will, would apply if the person were a different sex, sex being the prohibited basis of discrimination. I would only respond to your question by saying, in this case, it is possible that ExxonMobil could come forward with evidence to suggest it does assess every person, citizen and non-citizen, for their ability to accept and complete long-term employment. That seems to be what is behind the determination that you must provide, quote-unquote, permanent work authorization, an interest in folks who can be employed long-term. That is an interest that would apply to both citizens and non-citizens alike. So as in Bostock, you've got to ask, yes, this is a non-citizen, and who as a result of not being a citizen does not have permanent work authorization. Would this company treat a citizen with a similar inability to commit permanently to long-term employment to similar treatment?
Yeah, and I get that point, and maybe they would, and there's some insinuation that in the briefing that may be the case. But even before you get there, don't you have to connect citizenship more to work status along the lines that is done with sexual orientation and transgender status in Bostock? Those things seem to be factually connected here and not intentionally connected the way they are in the Bostock opinion.
Well, Your Honor, I believe that understanding the law on work authorization would indicate that they are directly and permanently connected. That being that all citizens have permanent work authorization. It will not change.
Well, I don't think factually that's true, but I don't want to beat a dead horse too much, but Bostock talks, that's a lot like a disparate impact theory. That sounds to me like factually everyone who has the temporary work status will be a non-citizen. That may be factually true. I think it is factually true. But that doesn't mean that know that Bostock says that's what answers the question. There's got to be a connection of needing to know the citizenship in order to determine whether they're classifying on a prohibited basis. And I just
Your
don't.
Honor, what you were characterizing as disparate impact, I would not characterize that way for two reasons.
Okay.
One, it's 100% under the law
Okay.
that a citizen, every citizen, has permanent work authorization. Now, that doesn't mean that there might not be other barriers
Right.
to long-term employment for those citizens, right? Every non-citizen, by contrast, does not have permanent work authorization. Even a lawful permanent resident does not have permanent work authorization if they were to violate a condition of being a lawful permanent resident, including, for example, failing to re-register after 10 years and therefore being unable to carry proof that they are in fact a lawful permanent resident. So as a matter of law, it is 100% on both sides.
Okay.
Second, I would assert it's really a tautology issue, right?
A what issue?
A tautology issue. Are you defining the class that's being discriminated in a way that simply means being a non-citizen? And that's what we would argue here. You can't, in essence, assume the outcome by using different words to describe a non-citizen class. But that's what you're doing when you describe the class as those without permanent work authorization, because by itself, that means non-citizen. So it is simply a different way of saying we are discriminating against all non-citizens. Now, in this case, they have exceptions. Those they call protected persons under IRCA, and that includes lawful permanent residents, asylees, and refugees. All three of those classes also have non-permanent, as I've explained, work authorization. So they do have
Well, it's
exceptions.
permanent, it just can be revoked, right? That's not to say it's not permanent, right? I mean, you know, listen, a U.S. citizen, in a sense, doesn't have permanent work authorization either, right? Because they could go out and murder a bunch of people and be executed, right? And that would mean they couldn't work anymore, right? They could be put in prison, right? But those are still permanent work authorizations. They just are subject to revocation.
Actually, Your Honor, for lawful permanent residents, that comes close to being true, though there is still a requirement every 10 years. If you are a lawful permanent resident,
That you
to
re-register.
re-register. If you
Right.
fail to do that, you can no longer comply with the rule that you have with you at all times, proof of your status as a lawful permanent resident. That then potentially leads to revocation, as you said, of work authorization. But with respect to asylees and refugees, there's a more frequent requirement, 2 years, to go in and re-register. And if you also seek work authorization, my understanding is your work authorization as an asylee would have an expiration date. It would then be reissued when you re-register after 2 years as required with a new expiration date.
But
So
that's
the sense of-
that's nothing that Exxon has anything to do with.
That's correct, Your
And
Honor.
why in the world would they buy into a suit like this, knowing on the front end that he was a non-citizen?
Your Honor, again, this is a question of whether they're discriminating on the basis of non-citizenship within a subclass of all non-citizens. It's the same as Connecticut versus Teal. It's the same as other cases decided by the Supreme Court. The fact that you, in the end, are hiring other folks from a protected class does not answer the question whether an individual, emphasize in Bostock that it is an individual question, that an individual is facing discrimination on the basis of a prohibited basis, such as alienage or non-citizenship here. So the fact that they do hire other non-citizens does not answer the question. Still, under Section 1981, they are prohibited from discriminating against any individual, including Mr. De Leon, on the basis of non-citizenship. In this case, because it was premised on his not having permanent work authorization, which is another way of defining and describing non-citizens as compared to citizens, they were in essence discriminating against him as an individual, as they also would against others who hold DACA. for being a
Can you
non-citizen.
answer, so I read Bostock as requiring two different things. One is a but-for cause, and Bostock seems to expand that a fair bit. And that was the issue that was at play there primarily. But the second issue, as Judge Quattlebaum referenced, is intentionality. And that both of those things are required, right? And this is the difference between disparate impact and intentional discrimination. Assume for a minute that I thought, or hypothetically, that alienage here is a but-for cause. I'm just trying to really understand the argument for how Exxon is intentionally discriminating on account of alienage. Like, help me understand how you meet that part. I mean, you seem to be focusing on the but-for cause side, and I think there are arguments both ways there, but what I can't really quite get my head around is the intentionality side.
So intentionality is shown by the fact that this is a categorical exclusion. There's no application of different criteria, looking into individual cases. It's a categorical exclusion. That exclusion is defined, as we've said, by whether you have permanent work authorization or not. That determination of permanent work authorization is entirely tied, 100% coincident, with whether one is a citizen or a non-citizen. So Bostock also tells us it doesn't really.
But then go back to the pregnancy case, right, from the 1970s before we enact the statute, and the Supreme Court there says, yes, 100% of pregnant people are women, but discrimination on pregnancy grounds is not on account of sex or on the basis of sex, right? In essence, saying it was a but-for cause of your discrimination, but it's not intentional because what the employer doing is discriminating not based on your gender, but instead on your status as being pregnant. And it, the statute overrules that with respect to pregnancy, but the principle remains.
If that had not been overruled by statute, I think Bostock would have severely undercut, and does severely undercut, that analysis. Because again, in Bostock, the Supreme Court tells us it doesn't matter what the employer characterizes its discrimination as, or how people in general would characterize discrimination. You've got to look at, is there a distinction that makes a difference between whether you're a non-citizen or citizen, or in that case,
So your argument is that either, you agree that if we don't view the statute as overruling the principle, instead just an update of the statute, and that Bostock doesn't overrule it, that it would control here and you got a problem on intentionality?
No, I do think Bostock would overrule it. That's what I'm saying.
And if it doesn't, I'm saying hypothetically, if I think Bostock does not overrule a case that it doesn't cite or otherwise discuss, then help me understand how, if it applies, and we'll give you a few minutes to answer, but if that case continues to apply, help me understand why it's not your case exactly in rejecting it, given that it's 100%, right? It's the same basic idea.
I think it's more than Bostock that undercuts the reasoning of that rather old case.
Assuming that the case continues to control, can you distinguish it, or do you depend solely on the idea that it's been implicitly overruled in some way?
Yes, every case since then, the court has arrived at more general descriptions to apply it from one sex to the other. So instead of, in the subsequent case, are you capable of getting pregnant or not, it's are you fertile? So then that's applicable to men as well as women. That's Johnson controls. So in this case, the same. Here, what is the general principle? Are you available without any barrier for long-term employment? That's applicable to both citizens and non-citizens. And the question in this case is, does Exxon apply that to both citizens and non-citizens? At this pleading stage, what we have put forward based on what we are aware of is that it does not apply to citizens as well. Now, if we got past this stage and evidence came forward that, in fact, they do assess even citizens' ability to whether there are any barriers to long-term employment, you mentioned some of them, are they potentially indictable, et cetera?
Thank you, counsel. You got some time on reply? Oh, I'm sorry, Judge Quattlebaum.
I'm sorry to go, then I'm actually going to bring up a different topic, so I apologize to my colleagues. But The first step that is briefed is whether the implied cause of action under 1981 exists here. And I've read the briefs, and I'm not going to go into this in detail. But does the Bivens analysis, the analysis that we look to see whether to apply a Bivens case, is an extension, are there special factors? Is that the same analysis that we would apply here to determine whether there is a cause of action?
I don't think so, Your Honor, but let me first say this was not fully briefed, and we would welcome further briefing if that's where the court chooses to go. But I would say it's different.
Comcast, cites to the one of the to Bivens or one of the case. I can't. It may be Agassi.
Yeah. So, but the reason I think it's not is that we have all of these cases up to Bostock that describe what does it mean to prohibit discrimination on a basis. We know this court decided in the 1990s that private discrimination on the basis of alienage is prohibited by Section 1981. What Bostock tells us is even though when Title VII was enacted in the 1960s, we may not have anticipated this. It was there. When you prohibit discrimination on the basis of sex, that necessarily includes prohibiting discrimination on the basis of sexual orientation or gender identity, essentially what the court said. So this is not an extension. This is, we decided.
Maybe let me cut you off. I'm not debating right now whether whether it is or is not an extension. I mean, but that's the Bivens questions, right? Number one, is an extension. Number two, are there special factors, suggesting we shouldn't do it? My question is not whether
your question is that's the analysis.
Is that the analysis we look to?
I think it's debatable, Your Honor. I think that may be specific to Bivens. That may be specific to Bivens, but I would not say there's any clear answer to whether that's the analysis that would be applied.
You have an alternative suggestion for how we'd look at it?
Again, my assertion would be that even if you looked at those criteria, this is not an extension because it was embedded in the initial determination that private discrimination against aliens is prohibited.
Okay.
Mr. Lynn, we're happy to hear from you.
Good morning, may it please the court. Albert Lynn on behalf of ExxonMobil. I think perhaps the clearest illustration of why plaintiff's theory is wrong is that it would make per se unlawful. It would make it per se unlawful for employers to have a policy that explicitly refuses to hire individuals who need or have a visa. That is something no one disputes is permissible, including the Department of Justice.
Is that really right? Because first of all, even if that's true, like that's a consequence. But if that's what the law requires, that's what the law requires. But do we think that if there was a law, so if Congress passed a separate law that says to employ someone they must have a visa, that would similarly fall into this boat? I wouldn't understand your colleague to suggest that that would apply here because that specific would govern.
No, Your Honor. I think if we take a step back and consider what their theory is, right? I mean, he said a couple times that it's this issue of 100% impact. I mean, plaintiffs, his contention is that a policy is unlawfully discriminatory on its face, right? If by its terms it differentiates on the basis of a trait unique to some non-citizens and only non-citizens. And so here the issue is temporary work authorization. That's the unique trait that applies only to some non-citizens. But I think needing to have a visa is also such a trait. So I think that's why that illustration is helpful here. And ultimately, Your Honors, I think the flaw in plaintiff's reasoning is that he's trying to prove facial discrimination through disparate effect alone. And Your Honors have mentioned disparate effect a couple times today. And I think that's really the problem here. In their reply, they make clear that their one and only claim in this case is that the policy is discriminatory against non-citizens on its face, which, if true, would make the policy per se unlawful. But the mere fact that a policy has a certain effect on non-citizens, which is what he has emphasized here and in his briefs, doesn't make that policy discriminatory on its face. right? Those are different questions. Whether something is facially discriminatory depends on what the policy says and whether it identifies as a protected basis, a trait, identifies as the differentiating principle, a trait that is protected. That is a different question.
But Bostock, the express basis for the discrimination was not sex. It was sexual orientation or gender identity. And so, we gotta deal with that. I mean, there was a description that was different than on the basis of sex. Just like here, there's a description that's different than on the basis of alienage. So does Bostock take away the argument that, look, they didn't write into the policy citizenship?
So two answers, Your Honor. To your second question, no, I don't think it does. I think.
How not? I mean, the policy in Bostock was not expressly on the basis of sex. The court looked at it and said, you can't separate the two, basically.
Yes, Your Honor, and that's my second answer, which is sort of what was going on in Bostock. But I think just to make clear, I don't think it's a fair or correct reading of Bostock to say that it has implicitly eliminated all of the cases that address how you deal with facially neutral policies. There are still such things as facially neutral policies, and for that, there has to be more, right? One thing that you could allege is a disparate effect, but in 1981, there has to be intentional discrimination. So you also have to allege facts that, if true, would prove a discriminatory purpose. So that's my first answer. I don't think Bostock eliminates all of the cases, over the years that deal with facially neutral policy. I think that is true. Those still exist. So.
But does it, I think that's probably not a lot of disagreement on that generally, but does it eliminate it for policies that classify on a basis that is, inescapably and intentionally connected to a prohibited basis?
I think I would use similar language to what you just said, Your Honor.
Okay.
I think the issue in Bostock, and you asked my friend that question, is that the traits that were at issue there can't really be described or explained or analyzed without reference to the protected basis, right? And so there's that whole discussion in there about whether you would say in kind of changing one factor to see if the outcome is, changes, that you have to describe it as being attracted to a person of the same sex.
Right.
Attracted to a man, right? You have to sort of describe it that way. This is different, Your Honor, and you asked that question.
Can you talk to me just a second about the level of generality of the description, right? Because at least rhetorically, you could change Bostock by saying, my category is not people who like men, which then requires knowing whether you're a man or a woman to know whether you're going to be affected by the policy. But instead, the policy is homosexuality, right? And so if you describe it at the high, like a slightly different level of generality, the question becomes, well, if I'm discriminating against anyone who's homosexual, it doesn't matter whether they're a man or a woman. I'm discriminating on the basis of the description. And I take Bostock to tell us we can't be this broad. We got to go to the conduct or the more specific. And I'm wondering how that applies here, because your colleague wants to suggest instead of the specific, that is like work authorization, it's more general, like do you have a long-term interest in like continued employment with us? And is that the same move? Am I thinking about that the same way? The long-term interest in employment is the Bostock equivalent of calling someone homosexual, as opposed to liking men is the equivalent of lacking work authorization?
I understand your question, Your Honor. I think the analysis of what was happening in Bostock is, to be candid, I think a difficult one, and that was obviously the dispute between the majority and the dissent. I think the way you understand Bostock is that again, I think it comes back to the idea that you can't describe that particular trait that was at issue without reference to the the protected trait there. But I think more importantly, I don't think any of that is relevant here. And I think that's because if you look at the actual policy that's at issue, that's pleaded, and that's at paragraph 27, it's not simply the statement, you have to have permanent or indefinite right to work in the United States, although that is the shorthand. It then goes on, and there's a parentheses, i.e., and explains specifically what we mean by that shorthand. And what we mean by that shorthand is, and it says, you are a protected individual under 8 USC 1324B. And that lists a number of specific individuals. Citizens is one of them, asylees is another, refugees is another, permanent residents is another. So my friend has talked a lot today about whether what's really behind the policy is not wanting to hire people who have a practical, long-term inability to work. And I think that's wrong for two reasons. The first is, we don't look at what's really behind the policy. In his reply, again, he's expressly disavowed the idea that he's challenging a facially neutral policy, right? And that you go into the McDonnell-Douglas analysis and kind of figure out what, whether there's a secret intent. He says at pages 5 and 6, that's not what he's claiming. He's claiming that this is discriminatory on its face. So the first problem is you don't think about or look at or explore whether there's a pretext. But the second is, I think when you look at the policy as it's pleaded, right, we're at the motion to dismiss stage, so it's his words. The policy doesn't only say permanent or indefinite right to work, it then defines that specifically as you are a protected individual under 8 USC 1324B. So, Your Honor, to your Bostock question, I think that's a complicated one. I think it there was unique to the idea that to describe the trait at issue, you have to reference the protected basis. But I don't think that we come anywhere close to that complicating issue here.
Let me change course a minute. Does IRCA require immigrant workers to exhaust their alienage discrimination claims through its administrative process, or is that streamlined process merely optional?
Your Honor, to be honest, I don't have an answer to that question. However, I don't think it would apply here to Mr. De Leon because he's not a protected individual under 8 USC 1324B. So he's not covered by that statute, which is really sort of the point here.
So he can pursue his claims under 1981 in a different manner.
Yes, assuming setting aside our alternative argument that Judge Quattlebaum raised about whether a DACA recipient or someone who's not lawfully admitted even has an implied right under Section 1981. But that is an alternative argument that we don't think you need to reach. I think you can assume for the sake of argument that he does have an implied private right of action, and you can simply find that the limited claim that he has brought here, which is the allegation that this policy explicitly discriminates on the basis of citizenship on its face, I think you can find that that is not true. The basis for the discrimination here is whether you are a protected individual under 8 USC 1324B. And so if you have kind of picture a decision tree, right, where there's a branch that goes one way and a branch that goes the other way, and there's that node at the top. What is the differentiating factor that puts you down one side versus the other? That differentiating factor is not citizenship. If it were, one side would have all citizens and the other side would have all non-citizens. But what happens here is you have citizens as well as a whole bunch of other people, non-citizens, refugees, asylees, people with permanent residency. And on the other side, yes, Your Honor.
For sure. But I think that's been kind of conceded factually from the get-go, that there are plenty of non-citizens that Exxon appears to hire, and the facts here that they hired this plaintiff, suggest that. I don't see how that lets us not grapple with the issue that Judge Richardson raised, which is because Bostock comes in and talks, and is a decision that says even if the policy has is based on something that's not the specific protected characteristic, you have to, you can do, it still can be prohibited if there's some connection between a, characteristic or a basis that is not, explicitly the protected trait. So I don't see how, your definition, which goes in the protected class, does anything to keep us from trying to figure out what we have to do with Bostock and whether to engage in that more specific analysis versus that more general analysis. If I've misunderstood that, I'd love to hear how, but it seems like Bostock, if we were to change the analogy and use, sexual orientation and transgender, you still would have the same situation. I mean, it's not facially discriminatory except for the connection of that with sex.
Your Honor, I don't think we're really that far apart. I think the Bostock methodology does apply. I think the question is what Judge Richardson posed, which is, how do you define these traits, right?
That sounds kind of a weird way to end up resolving it by picking a specific trait versus the more general way you describe it.
Right.
On the other hand, that's how, the court there links sex and sexual orientation.
Yes, but I think the way that, this court can resolve that in this particular case is, I mean, again, I think it's a couple things. I think the way you understand Bostock is you have this potential ambiguity disagreement, right, about how you might define it, what level of generality, because it is a trait that is related to, intertwined with, right, can't be described or understood without reference to the protected trait. And I just don't think that's true here. I think what you have, and I think, frankly, I think IRCA illustrates that well. IRCA talks about certain non-citizens and then distinguishes amongst them, right, on the basis of their immigration status or their work status. And it says, the protected non-citizens here are permanent residents, refugees, asylees, and then there are some that are not protected, which include people who need visas, as well as individuals like Mr. De Leon. And I can't imagine a way where you would describe that, or you have to describe that based on their non-citizenship. It is a separate trait, though it is one that is, only held by non-citizens, it is one that can be distinguished distinctly in a very easy way. And I think the facts here, and Judge Floyd referred to that, the facts here show that, right? I'm sorry, Your Honor.
No, go ahead.
I was just going to say, all we knew about Mr. De Leon was that he was a citizen of Mexico. He was offered the internship. It's when we found out more as the application process went forward about his specific status and work authorization and whether he fell under 8 U.S.C. 1324B. That distinct trait is why the internship was revoked. So I think Judge Richardson...
Are we talking about in that context?
Go ahead.
When I think about Bostock, help me understand if what I am thinking is right, and I want you to disagree if you do. This is not a leading question. But I think of Bostock as having these two pieces, right? One is but-for cause and one is intentionality. And it seems easier here to talk about alienage as the but-for cause of lacking work authorization, right? Given Bostock's broad language, that seems to be an easier fit than intentionality. Is that the right way to think about Bostock, and is the right way to think about this case? Is that even if it's, technically a but-for cause of lacking work authorization, that being alienage, there's no intentionality as Bostock found it, the sort of example that Judge Quattlebaum gave earlier about showing up with your spouse that is a man, and unless you know whether the employee is a man or a woman, you don't know. So that requires intentionality. Is that the way of thinking about it, or am I missing something in that analysis?
That's not how I read Bostock, but But I think we end up getting to the
All right, so
same.
help me understand how you read it.
So how I read Bostock is that what was happening there was there were sort of two traits at issue. There's gender or sex, right, which is the actual protected trait. And then there's, whether it's homosexuality or transgenderism is the other trait. And then the question is, in step one, you have to kind of figure out how you define that second trait. And then step two is you change only one of those traits and you figure out whether that change would be outcome determinative. So
Doesn't Bostock pretty much, that change one trait, it says it, and then later seems to say, well, but it seems to say that and then almost reject it later in the opinion.
No, Your Honor, I don't think that's right. So there is a section where it is addressing, it says the other side argues. I think what it says is that it claims that the company is, accusing is too strong of a word, but the company is contending, right, that the analysis ultimately adopted by Justice Gorsuch was actually changing two traits. And I think what Justice Gorsuch says is, no, I'm only changing one trait. And the one trait that I'm changing is the sex of the individual. What I'm holding constant is, just to use homosexuality as the example, that the individual is attracted to men, right? So a man attracted to a man versus a woman attracted to a man, which, is that outcome determinative? Versus if you held sex constant, a man attracted to a man versus a man attracted to a woman, right? And so he kind of changes those things and figures out whether that change is outcome determinative. If you do that here, the issue is, you have a non-citizen, that's one trait, who is not a protected individual under 1324B, or as we also put it, doesn't have a permanent or indefinite right to work. Then you have a citizen who is not a protected individual under 1324B, doesn't have a permanent or indefinite right to work. But you have to hold that constant. Does that change in citizenship result in differential treatment? And the answer to that is no, it doesn't.
And why doesn't it matter that your comparator is a null set? Right? I mean, the citizen that's not 1324B doesn't exist.
It doesn't exist.
Right.
That's right.
So why doesn't that change the analysis? I'm totally with you, but I just want to make sure I understand your position on the fact that it's a null set. Why is it that doesn't matter?
I think there's two ways to look at that. One is sort of at a kind of a theoretical or logical level, which is there is then no disparate treatment. There's no other individual that is being treated differently. And in the cases that we cite, the Sex Plus cases, the 8th Circuit and the 10th Circuit and the 6th Circuit have all said that. They've said when you have that null set, you can't establish that logical requirement of discrimination or disparate treatment because there is no one who is being treated differently from you. I think if you think about it in a factual way here, that null set person is not being treated differently because that null set person can't be hired. Doesn't exist. So it is practically the same treatment. So I think there's sort of two ways to think about why that null set issue is a problem.
Hopefully this is short. Do you, back to the last question I asked your colleague, is it Exxon's position that the way we address the existence of the cause of action is through the Bivens lens?
So my time has expired if I may answer.
Please.
Your Honor, when you were asking, I think the short answer is basically yes. You had alluded to the fact that Comcast, which addresses 1981, refers to Ziegler, which is the Bivens case. And it talks about how we should be cautious about implied rights of action. So I think the short answer is yes. I think more broadly, the court has said on a number of instances that the days of the implied right of action are different from those today, and that as a general principle, there should be caution exercised in extending implied rights beyond what the Supreme Court has done. Thank you.
Thank you, counsel. We've got some time on Rebuttal?
Thank you. I first want to point out that no matter how you describe the discrimination here, either the ways proffered by Exxon, it is inextricably connected with alienage and immigration. First of all, the whole notion of work authorization did not exist prior to IRCA. Prior to IRCA, there was no such thing. It is entirely tied to Alienage and Immigration Reform and Control Act. And the second description they use of protected persons comes directly from IRCA. It is entirely a creature, once again, of immigration, therefore inextricably tied to alienage. So as far as the connection between the protected category, alienage, and what's going on here, it is inextricable. In the context of employment, there's really no way to figure out what Exxon's interest is in this issue, except by then going to the more general description. They're looking for folks who have the ability without barrier to commit to long-term employment. That is a description that applies both to citizens and non-citizens. And that's the appropriate way of approaching the question. If you end up with a null set, as was discussed recently, and the comparison you're making doesn't exist among those who don't have the characteristic protected, that means you probably have a tautology problem. You are in essence
No, but
describing...
we have that issue come up all the time. Right? We see in traditional employment cases all the time, somebody shows up and is attempting to prove discrimination and they lack a comparator. And if you lack a comparator that was treated differently, right, that null set generally means you lose. Not 100% of the time, but it generally means you lose.
Generally, Your Honor, I'd say when that occurs, you can come up with a more general description that could apply to the other, but the null set is not really null, but it's so small because it's such a small issue that it doesn't really rise to the level of being discrimination. That's not true here. Here, there's only a null set
I'm sorry,
because the description...
I don't understand that. So,
If I could, the null set exists here solely because what's being used to describe the issue is entirely tied up with alienage. As I said, the whole notion of work authorization did not exist other than in the context of alienage. So their first description, do you have permanent work authorization, is meaningless outside of a connection to alienage. Their second description, are you a protected person, also tied directly to alienage. Both of those, the problem is, they are in essence a description of the protected class. I think the analogy would be in Bostock if you said the employer is discriminating not against women, but against lesbians. And by the way, lesbians don't exist among men, therefore, we can discriminate in that way. That is an analysis rejected in the Bostock case. You can't define it at a level that is in essence a description of the protected class. You've got to come up with, as best you can, if you can, a description that cuts across both the protected class and those outside the protected class, and ask, are you treating folks in both classes the same with respect to that attribute? Here, the only descriptions offered are in essence tied to whether or not you are an alien, a non-citizen. I have to just comment with respect to the second, are you a protected person? The only connection to employment relates then to discrimination prohibited under IRCA. It's somewhat curious that they would, at Exxon, describe it that way, because in essence, they seem to be implicitly saying we would like to discriminate against all non-citizens. But there's this law, IRCA, that says we cannot. So the only way you will be free from our categorical preference for citizens is if you are protected under the law from discrimination by IRCA. Problem with that is they didn't incorporate Section 1981. And IRCA and Section 1981 are different, though both prohibit discrimination against non-citizens. IRCA sets up for a select class subgroup of non-citizens a streamlined process, not as arduous as going to court, filing a complaint, going through trial, etc. It's an administrative process. You go through an administrative agency that investigates, presents the case to an administrative law judge, and by very strict timelines, you end up with a resolution fairly quickly. That was established specifically because of concerns about what IRCA itself, through the introduction of employment sanctions, might mean in terms of discrimination. It is not the full scope of who is protected within the non-citizen class from discrimination because of Section 1981. In essence, every way to describe it is, in essence, a description of the protected class itself, inextricably tied to alienation. Thank you.
Thank you, counsel. As y'all both well know, we would love to come down and greet you and thank you for your argument, but we certainly appreciate you being with us and hope that we get a chance to see you in person before too long. Ready whenever you are, counsel.
Thank you. Good morning. May it please the court. The issue in this case is whether the district court improperly granted summary judgment to defendant. And of course, on a motion for summary judgment, all the facts and inferences that can be drawn therefrom are to be taken in the light most favorable to the plaintiff. The facts in this case are not very convoluted. First, my client was employed in 1999 as an Amtrak train attendant. He was later promoted to assistant conductor, and then for the last 7 years of his employment, he was a conductor. In his 16 years of employment, he had 3 relatively minor infractions that would be considered disciplinary actions. Now, he was terminated on April 19, 2015, or he was given notice, on May 6, 2015, that he was being recommended for termination by his supervisor, a fellow named Michael Hibbert. Mr. Giles was covered under the Sheet Metals Airlines Railway Transportation Union. He was covered by a collective bargaining agreement. After he received the notice of the proposed termination, he pursued a grievance through that. Under that collective bargaining agreement, there was a hearing before an arbitrator. The arbitrator ruled against him, and the decision of the arbitrator was upheld by the Public Law Board. Now, as much as he disagrees with the decision of the Public Law Board and the arbitrator, he accepts that decision. So for all intents and purposes, references to the collective bargaining agreement are over and done. And he is not pursuing at this level an interpretation of the collective bargaining agreement. He said, it's done. You've made the board has made that decision. So the question then becomes whether, in looking at the termination, we can look to what happens before a recommendation of termination is made. And that's the issue that Mr. Giles brings to you. The collective bargaining agreement is invoked when management decides to take a disciplinary action against an employee. If it doesn't decide to take a disciplinary action, then it's not invoked. I'm not arguing about the shades of discipline or the levels of discipline, but the mere decision by management to commence a disciplinary action or not commence a disciplinary action. Now, this is a discharge case, and as such, we have to prove that Mr. Giles was in a protected class, he suffered the adverse action of the discharge, that he was performing at the company's expectations and that others similarly situated to him outside of the protected class were treated better. There's no question about the first two elements. And we say that evidence that the plaintiff submitted with the inferences that can be drawn therefrom will show that he met the expectations. Now, meeting expectations does not mean, this court has said, that he has to be the perfect employee or he has to have a perfect record. Whether his performance is satisfactory was stated in this record by his supervisor, who said that he was a good conductor and that he followed instructions. So there is evidence in the record from his own supervisor that he was a good employee and following instructions. Whether a person is meeting the expectation can be and should be evaluated based on whether they are treated differently from others. And that's a question of fact. In Hong versus Gutierrez, the plaintiff there was able to show that while the defendant said she was not performing satisfactorily, that there had been evidence from her own supervisors that they had told her that her work was good. They chastised or they complained that her work was not turned in timely manner, but yet also admitted that she had in fact turned in her work in a timely manner. So she was being evaluated differently than others. And so then the question is, what really were those expectations? And this court in Haynes said that you can look to, and that's Haynes versus Waste Connections, Inc. out of South Carolina, that you can look to how the company says it expects performance and how it actually evaluates that. And so in this case, Mr. Giles claims that his performance was satisfactory.
Can you just talk a minute about the insubordination?
Sure. I'm getting that, yes.
Well, I know, but we're going to run out of time if we don't get to it. So, all right, you can be really good at your job. One of my clerks over there, he writes well, researches, does all that thing. But if I ask him to do something and he says no, I refuse to do it. Barring some, limitations on what I can ask him to do, like, that's insubordination, and he's going to get fired.
That would be insubordination. And you would be justified in firing him if other people did the same thing but were not fired. And the evidence...
I would be justified in firing him
if
other people did the same thing and were not fired.
And were not fired.
So I could fire him in that scenario.
You could fire... We're not arguing that an employer cannot take a disciplinary action against an insubordinate employee. What we are arguing is that if insubordination is that important and that critical as a part of its disciplinary process, then the court needs to look to see whether similarly situated people outside of the class engaged in insubordination.
Well, in that regard, do you have any non-hearsay evidence regarding Mr. Martino's allegedly insubordinate behavior?
Your Honor, I take the position that the statement of Mr. Hibbert, the supervisor, falls under 801D2D, which says that a statement by an agent or someone acting on behalf of the company within the scope of that employment taken during the relationship is not hearsay. Now, I am not arguing to you the statement of the co-workers as to what Martino and Hibbert said are non-hearsay. I'm not making that. I'm only talking about Hibbert.
Well, in that regard, would the company be entitled to consider the severity of the insubordination, for example, refusing to decouple a car has some significant safety issues as opposed to refusing a schedule?
Your Honor, insubordination is insubordination. The degree of discipline may vary, but in this case, the record is void of any disciplinary action being taken against this white comparator. And
So counsel, I mean, assuming that the party and interest provision applies, the record does talk about what Judge Floyd said, that this refusal to do an act affected safety. So it seems, maybe you're right. I mean, certainly it could be reflected in a different type of punishment or disciplinary action, but doesn't it also go to whether they're similarly situated?
if I may, Your Honor,
For sure.
yes, it goes to whether they are similarly situated. But when you're looking at the defendant's reasons for these two not being similarly situated, they raise a question of safety versus scheduling. If safety is so important to this company, it should be concerned about all safety. And our evidence shows that there was a white individual who threatened to kill a coworker, and he was not disciplined. So the law is that there is it's a question of fact. This articulated reason does not have to be taken face value just because the company articulates it. If the plaintiff puts evidence forward to question or bring into question the veracity of that articulated reason, then he should survive summary judgment, because all of the inferences are supposed to be taken in his favor.
Does it matter at all, maybe under pretext or maybe another thing, does it matter at all the level of kind of scrutiny that was placed upon this action? That not only did you have the termination, but you had a review of that through the grievance process, multiple levels, all, concluding the same thing. I know you started off by saying you're not really questioning what happened through the grievance process, but is that something that we should just kind of ignore, that not only do you have the company doing it, but you have a, collective bargaining process, where that, has some degree of, I guess, favoritism or intent to protect employees, and they don't just affirm, they talk about gross insubordination.
Your Honor, you cannot excuse discriminatory conduct simply because the case presented to the grievance board was affirmed by the panel. What would help you distinguish between the actions taken with respect to the comparator and my client is, did the company at the first level, say some discipline should be imposed? I'm not arguing the severity of the discipline necessarily, but if there is a disciplinary act or violation and no action is taken, and let's talk about this severity. What we're talking about is taking the train apart. They had dragged that train from New York to Raleigh, and they were just uncoupling it. It wasn't a question of whether the train was going to run off the track. And by refusing to work a schedule, the comparator also put safety in issue. There are minimum staffing requirements on the train. The conductor is an important part of this. The record shows the duties and responsibilities of the conductor. And so if you're talking about sending a train out where somebody has refused to perform work, then seriously, there's a safety question there. And I'm not going to ask the court to get into a weighing or a valuing of what the defendant says it needs to run how it needs to run its business. I think the court is clear that you're not going to sit as a super personnel body. But the action of not even raising a disciplinary action or a violation is a problem.
Pam,
Now-
in your opening brief, did you argue that Mr. Hibbert's statement about Mr. Martino met the hearsay exception?
I'm not sure that I'm not sure that I did. I don't think that I did, Your Honor, but I'd be happy to.
I mean, if you didn't, is it not waived?
No, Your Honor, because we contended throughout the essence of the evidence that the statement was from a manager, was in the course of his work and within the scope of the work that he was doing, and he was employed when he did it. I would like to say, Your Honor, also, that on the question of whether race was a but-for factor, we can consider other evidence of race discrimination. And our evidence shows that there was a culture of acceptance of inappropriate racial behavior, including a noose being in the workplace, racial epithets, including calling African-American women black big mammies, racially derogatory sticking papers in locker rooms, and even...
You've got some time on rebuttal that you can continue to raise these arguments if you'd like.
Thank you, Your Honor.
Thank you very much. Counsel, we're happy to hear from you.
Thank you. May it please the court, my name is Steve Dellinger. I represent National Corporation, I represent Amtrak here. And let me start off by saying that there is no recommendation from the supervisor here, Hebert, with respect to a termination. All that was done was Mr. Gills was placed on a suspension. It was left up to the arbitrator to determine whether or not the suspension falls within the confines of the collective bargaining agreement and was a major offense, and was also up to the arbitrator to determine whether or not it would warrant termination. So there's no recommendations being done at all. In fact, the sole purpose of the investigation, the investigatory hearing, is to determine what occurred. And it is correct. There's really no dispute about what really occurred here, and that is that Mr. Gills refused on 3 separate occasions to Trainmaster Amy Signs that he was not going to participate in the uncoupling of the train. In addition to that, it's also undisputed that he did not participate in the briefing associated with uncoupling the train. He testified that the purpose of a briefing is to make sure that everyone knew their job and to make sure that it was a safe operation. Now, uncoupling is more than just unhooking it. As the record shows, you have to know what you're doing. You have to have certain steps in place because it's subject to, really, electrocution. So there are safety concerns here that are in play. In fact, of the charges that were brought and looked at, there were 5 charges. 3 of those have a safety component in them. So to argue that an insubordination is just insubordination is incorrect. You've got to look at the comparable seriousness, and I'll use that in quotes, and that's from the Supreme Court decision of McDonald versus Santa Fe Transportation. It's the 1976 decision. In addition to that, later on, the Supreme Court in Helms versus Salem said you have to look at the gravity of the offense relative to what occurred. So if you really take all this together, you do need to look at the comparator here. In fact, their whole case here rises and falls on whether or not this Tony
Martinero is in fact a comparator. Now, you've asked some questions with respect to, and she concedes that the declarations are inadmissible. So all that's left is an alleged statement by Mr. Gills that he spoke to his supervisor. And the supervisor said, this guy, doesn't even identify the guy, has refused my orders twice and spoke to me in an aggressive fashion. That's all that we have, assuming that's even in. And I question whether it's in, because what she wants to argue that it is offered against an opposing party. What we don't know here, and what's required according to Hassan versus Caldera, which is a 2000 decision from this
Just so
court.
I'm sure that I understand the evidence we've got is Mr. Giles saying that Mr. Herbert said that this other employee refused an order.
That's correct.
And so the truth of the matter that's being asserted is that the other person refused an order.
That is the truth of the matter asserted. That is correct.
Right, and so it's not that so if it was something Mr. Herbert was for the truth of the matter, that'd be a statement by a party opponent.
That's correct.
But here
We
the
don't have
statement is by Mr. Martinero?
Martin,
Whatever it is, whoever this individual is, like, that's the statement that's being asserted for the truth of the matter, right? That person was insubordinate,
That's correct.
right? That action, those statements, I refuse, is the statement being asserted for the truth of the
That is
matter.
correct.
So I'm not sure I understand, frankly, why it falls within the exception.
Well, because again, we have, if you're going to argue that statement is a statement against a party opponent, that what you're hearing here is that the supervisor is relaying this conversation to Mr. Gills, and that is somehow a statement against a party opposing party. What we don't know here is whether or not the supervisor, the ability to do something about it even falls within the realm of the supervisor's authority at that time. So what I mean by that, for instance, we don't know whether or not the supervisor has the authority to write employees up. We don't know that. We don't know whether the supervisor here has the authority on his own to do anything. In fact, Mr. Gills kind of undercuts that entire argument because he says that he doesn't even believe the supervisor was the one who made the decision to write him up. He says that he was told to write him up, but he doesn't identify who that extra person is. So Mr. Hibbert could have said a lot of things, but we don't know whether or not that even falls within the realm of his authority. And if it doesn't fall within the realm of his authority, well, then it can't be a statement against an opposing party because there's nothing to back it up. But even if you want to assume, for instance, that he is in fact, that this statement is allowed to get in, again, there's a completely different concept here between this not working an extra shift in schedule, which there is no evidence on the record that created a safety issue at all with the train. In fact, the brief by Mr. Gills shows that it was easily rectified. They got somebody else, another conductor, to finish the train on to Washington. So there's no safety component here.
Counsel, could I kind of go maybe back to a threshold issue that you argued, the preemption of the act? And I just want to explore that a little bit. I mean, you claim, and I know the district court, it's ruling on this, but since you appealed that, you indicated or claimed and argued in your brief that the issues here require an interpretation of the collective bargaining agreement, but you never really identified the provisions of the agreement, or at least that I could tell what you were talking about. So help me understand that. I mean, if you're saying that any grievance that comes up through, is preempted, that's one thing, but you haven't identified in any way that I could tell what the actual provisions were and what interpretation was required.
It's whether or not the actions constitute insubordination which is identified in the collective bargaining agreement as a serious offense.
But that's, I mean, in any grievance that sort of, if that's the answer, it seems like almost any grievance would require an interpretation of it.
I don't believe any grievance would require the interpretation of the collective bargaining agreement. But when you've identified a particular rationale for why someone is being terminated that falls within the definition or within the terms of the collective bargaining agreement, here insubordination, the issue is, is it in fact insubordination or is it not insubordination? If it's not insubordination, you've got to look at the collective bargaining agreement to make that determination. And so, for instance, and if you also here, look at Mr. Gill's entire defense here. His entire defense is, yeah, I refused it. I refused 3 times not to follow through with Amy Sign's instructions until I found out who she was, and then I went ahead and complied with it. He says, so his excuse is trying to argue it really doesn't fall within the concept of insubordination. I wasn't insubordinate because I didn't know who she was. I wasn't insubordinate because I thought...
Would it make any difference if there was no insubordination provision in the collective bargaining agreement for this case? And that's where it sort of gets at, right?
Yes, I believe it would. If there's no insubordination term in the contract, and where it said that it was a serious offense or a major offense, I wouldn't be making this argument, because it would be something that there's no interpretation needed in order to make this decision. But the Railway Labor Act...
So that wasn't the question I was trying to ask, but let me come back to it.
Okay.
So the challenge here is that, if there was no insubordination, I'm asking a hypothetical, I understand that. If there was no insubordination provision in the collective bargaining agreement, and even so, seemingly reasonably, you fired somebody for insubordination, even though it wasn't in the agreement itself, and didn't fire a white guy who did the exact same conduct, whatever we want to call it, then we would have a claim in this context that wouldn't depend on the collective bargaining agreement at all.
That is 100% correct. Assuming insubordination is not part of the collective bargaining agreement.
So now imagine that the scenario you've got, which is insubordination is prohibited, but the plaintiff is not claiming that the collective bargaining agreement applied or was improperly applied against him or this other person, but just that they engaged in comparable conduct and were treated differently. It doesn't turn on the collective bargaining agreement at all.
Well, but that's not what Mr. Gills is doing. He's actually arguing here to some extent that, in fact, what's occurring here is that I was not insubordinate. He's not, and because you have to look at the contract, because it's a term in the contract, and it requires an interpretation of whether or not he
complaint, help me understand, where am I looking at for the complaint for him to say that he was improperly fired for being insubordinate? Like I don't see that argument. I get you want to add to some extent in your statement, but help me understand what part of the complaint does he allege that he was not insubordinate and therefore should not have been fired?
Well, you look at his deposition testimony, and you look at also the hearing transcript.
I got to look at the complaint, right? I mean, whether it applies or not turns on the complaint, doesn't it?
Well, I would argue that I would say that the complaint is a factor.
Start with telling me where in the complaint I might look.
There's nothing in the complaint.
And then in the deposition, tell me where you want me to look for the proposition that, for purposes of this case, not just that he believes it in his heart, but that his claim depends on him being improperly fired because he was fully subordinate.
Well, I'm looking for the record pages right now.
Or you can just describe it, right? When he says, I don't understand how in a deposition he makes a legal argument, but
Well,
then he does.
he's
Help
not
me
making a legal-
understand where it is, what part of the record. We can find it, but just describe it.
Again, what he's trying to do, he's not making a legal argument, he's making a factual argument. The fact is, I didn't do something that falls within the confines of insubordination. And he does that because he tries to excuse the conduct and says, I was told previously by my supervisor that that the Raleigh group was going to actually uncouple the train. Then in addition to that, I was also, didn't know who she was. So I can't be insubordinate to someone because I didn't know who she was. I didn't know she had authority to come ask me, to tell me to come do some things.
Yeah, I'm just, my memory, and you know the record better than I do. I mean, certainly I think as a factual matter, explaining what he did and why he did it. But I think the question is less about that and more about the claims. And so if he was asked questions and he gave his explanation, all that, that may be in the record. I kind of think I recall that as well. But if the claims are all based on a separate statute, which I think, I don't remember the citations, I think is what we have here, it seems like when you get to his legal theories here, they don't depend on that. And
Well,
maybe that's what I was trying to figure out is how does this relate to the actual claims he asserts?
Well, again, I read the Hawaiian Airlines versus Norris Supreme Court decision
Right.
that says that a matter is preempted if it cannot be adjudicated without interpreting the terms of the collective bargaining agreement. So even though you might have a separate statute he's trying to bring it under, it doesn't matter. If, in fact, you can't address the issue without interpreting the collective bargaining agreement. Here, it's our contention that you can't get into this whole issue without looking at the CBA and whether or not his actions fall within the confines of insubordination. And because you have to look to the CBA, it just preempts everything else. That's the whole concept of the preemption aspect of this. It's going to preempt Section 1981 in this instance. In fact, other courts have reached this conclusion. In Brown versus Illinois Central Railroad, a case cited in our brief, the Seventh Circuit held that America's Disabilities Act claim was preempted, where the plaintiff's claim required a potentially dispositive interpretation of the CBA seniority provision. In Dobson versus Norfolk, a Sixth Circuit in a disparate impact case alleging differences in discipline said because it required a view of what constitutes discipline, preempted a Title VII claim. And so there might be other claims out there that he's trying to allege. That's not the issue. The issue is whether or not the Railroad Labor Act preempts it. And again, according to the Supreme Court decision, unless you can, it's only independent if you don't need the CBA to help adjudicate or is needed to adjudicate the claim. Here, because of what he's saying is, I didn't engage in insubordination. You've got to look at the CBA to determine whether or not he engaged in insubordination, which is exactly what's all occurred with respect to the arbitration.
And Judge Rushing may have asked this, if he were to concede his conduct could be construed as insubordination for purposes of this case, and say you just didn't treat similarly situated people similarly, you would, in that situation, you'd agree there's no preemption?
I would agree if he concedes to that, because there's no dispute as to the meaning of insubordination with respect to the CBA.
Okay.
So,
As a factual matter, I thought Hibbert called Giles, and during the conversation, Hibbert told him who Sign was, and that he still refused to participate in the decoupling.
Well, actually, there's a little bit of disputed fact on that. You'll see that the district court raised that and said that that was our claim, and that's what our evidence showed, Your Honor. But there's a little bit of dispute by that. The plaintiff claims that after he learned through Hibbert who Trainmaster Signs was, he then immediately went and started uncoupling, which raises another issue, which is the whole safety component, because what he did was he then started to do something that he didn't engage in the safety briefing beforehand, which he himself testified was something needed and necessary, and it was, again, a major factor, the distinguishing any conduct that you have between him and Martino. And in fact, there's other distinctions associated as well with that. You've got, if even taking as true, the fact that Martinero refused an order. Again, we don't even know that this guy is actually Martinero, but assuming that it is, he did it twice. Will Gills did it 3 times. You've also got the fact, too, that something really significant here is you have a direct challenge by Mr. Gills to Trainmaster Signs, where he says to her, well, I'll take my chances at a hearing. So she tells him what to do. He pushes back and says, you can't do anything to me. I'll just take my chances at a hearing. That is a direct challenge to her. We don't have that with Martinero. We don't have him saying, well, take me to a hearing. What are you going to do about it? Martinero, at best, just says he isn't going to do it, and that kind of ends it. And then they find somebody else to supposedly to conduct the train. And then I think the other aspect of this is that who it was made in front of. This was a factor that both the hearing officer Mullen and the Public Law Board thought was very important. With respect to the situation as it pertained to Trainmaster Signs, there were 2 witnesses that saw it, that were there and present and with respect to what occurred. And then with respect to him being insubordinate by not going through the briefing but all of a sudden jumping on with the uncoupling of the aspects, uncoupling the train, there were passengers and DOT officials, which DOT officials are partners for Amtrak. And I'm out of time. Can I finish my sentence?
Sure.
Thank you. And the board and Mullen and the Public Law Board concluded that both those type of actions brought disrespect and embarrassment to Amtrak. And if you then take a look at all the cases cited, that is a truly showing the fact that when you look at comparable seriousness, the actions of Mr. Gills were far more egregious than that of Mr. Martinero. Thank you.
Thank you, counsel. You got a few minutes on reply.
Thank you, Your Honor. First, at page 251 of the record, there is a form, says Discipline Assessment Workshop. It has my client's name on it, it has the date of the incident, and it has manager recommending discipline, Michael Hibbert. It's dated May 5th, 2015. And the recommended discipline was dismissal. So Mr. Hibbert,
But that's a recommendation, right?
That's
Then
his
is decided
recommendation.
by,
it has to start from some manager, and it started with Hibbert.
right, but if he had recommended something else, the ultimate decision is not his. Whether he recommends dismissal or whether he represents a Baby Ruth, in both instances, the decision is not his.
That's true. But I was bringing that to your attention because counsel said that Mr. Hibbert did not make a recommendation and did not make a recommendation of termination. So I wanted to correct the court, bring that to the court's attention. Let me, Your Honor, say that the language in the record, in the deposition, shows that my client, Mr. Giles, spoke more than once about his conversation with Hibbert, but In particular, it says this, he quotes Mike Hibbert as saying, "This is the second time that this guy has refused my direct order and verbally abused me like this." So it wasn't just, "I'm not going to do it," but he was verbally abusive towards his manager. And in addition to that, he did not complete the work. So we believe that the evidence here is sufficient to raise a question when the evidence and all of the inferences taken in the light most favorable to Mr. Giles is sufficient to present this evidence to a fact finder and not have it decided on a motion for summary judgment. Now, there were witnesses, there were people at the train station in Raleigh. The record shows that one of the witnesses testified that he couldn't hear anything. And there's evidence in the record that there was a lot of noise around there so that they couldn't hear anything. So any discussion about what was said was not in this record. So those witnesses could not vouch for any comments that my client made to Ms. Symes. Now, on the issue of whether race can be attributed or race discrimination can be attributed to the decision maker, I think the court recognizes, as Staub versus Proctor says, that if there is race somewhere, evidence of race discrimination somewhere in the decision process, that it can be imputed to the decision maker. And what we have here is evidence of Hibbert himself using racially offensive language and ratifying behavior by others, as well other subordinates to him or non-management persons. And we have evidence in the record that another manager, Mr. Whitlow, also engaged in that conduct. We have evidence that that behavior was complained about by African-American employees and that it continued. It was, there's evidence, which is not disputed, that the white employees who engaged in that behavior were not disciplined. Now, you don't have the actual contract in this record. What you have is a little handbook that sets out, quote, standards of excellence. And those standards of excellence talk about being disrespectful, which is one of the charges that was brought against Mr. Giles. There's also evidence that none of those people who had engaged in that offensive conduct were ever disciplined, and that kind of behavior, at a minimum, you would say was rude. You would say that it was disrespectful. So if we're looking at evidence and inferences of evidence of discrimination, I think that the plaintiff has met his burden, has met the burden of proving the prima facie case, and when all of the evidence is merged, is sufficient to defeat a motion for summary judgment. And I thank you for your time.
Thank you, counsel. As you now know, having sat through a couple of these, we wish we could come down and greet you in person and shake your hands, but I hope you'll come back soon and we'll resume our tradition when you're back next. We thank you for your argument. We'll go to our final case, 21-1565.
May it please the court, Terry Grimes for Tammy Bandy in this case. As the court has pointed out, this is our last and final argument. It does come to you from the Western District of Virginia on summary judgment. It's an age discrimination case. I appreciate the opportunity for oral argument. It's a pleasure to be here. In this case, the district court got two things right and at least one thing wrong in my view. First, it got right the fact that there is direct evidence of discriminatory animus on the part of the panel in this case. And second, it got right the fact that the panel acted as a panel. That is, it was not Wendy Delano acting alone. It was the three members of the panel acting in concert to effect the employment decision in question.
To be fair, he didn't decide that. He said there's a genuine issue of fact about that, right?
You're exactly right, Your Honor. You're exactly right. There's evidence of that. It's a question of fact. You're right, to be decided by the jury. That's correct. What the court got wrong in our view is this, and that is, given that there's direct evidence of discriminatory animus on the part of the panel, that every decision, every action of the panel thereafter has to be viewed through that lens. That would be something that the social sciences might call confirmation bias, and I'll get to those points one by one. Of course, we're here on summary judgment. Anderson versus Liberty Lobby, the case could only be decided for the defendant if the evidence is so one-sided that one party must prevail as a matter of law. That question has to be answered in the negative here. So when Tammy Bandy applied for this booking coordinator position at the Salem Civic Center, she was told by Hank Luton, one of the panel members, that although her interview went well, we hired Jefferson Lee because he's much younger and more energetic. The we in that sentence was the three panel members. Judge Quattlebaum, as you have pointed out, that's a question of fact for the jury, but there's evidence of that fact, and the district court recognized that. Hank Luton was 38 at the time, and Chris Fisher was age 39 at the time. Wendy Delano was older. The plaintiff was 52, and Jefferson Lee was 23 years old at the time. And so the district court properly found direct evidence in this case. And turning to the but-for causation question, which is what in the first paragraph of its opinion, the district court says, well, there's not but-for evidence in this case that age was was the factor in this case that resulted in this employment decision. But I point out to you, although you do not need to decide this in this particular case, but-for does not mean the sole cause. The Supreme Court made that clear in Barrage versus United States, Bostock versus Clayton County. Justice Gorsuch gives several examples of why but-for causation is not the sole cause. But-for does mean what it means. But for the fact that the New York Yankees lost to the Houston Astros, they'd be playing in the World Series, I think, starting tonight. So in that sense, because the New York Yankees lost to the Houston Astros, they're not playing in the World Series. So in that sense, because and but for should be synonymous. And I think, I submit to you, the district court overlooked the significance of the word because in this case.
Counsel, do you have to present evidence that but for any age discrimination, your client would have been awarded the job?
I think there has to be direct or circumstantial evidence of that.
What's the evidence that if you take age out of the equation, your client would have received the job?
That's a fair question. That gets to my second point, because what the employer says is, well, we chose Jefferson Lee because he had more education, for example. And that's true. He has more education than the plaintiff. He has a college degree and she does not. But the job only required a high school degree, did not require a college degree.
Let me interrupt you. And I think I hear your answer seems to be talking about your client in comparison to Mr. Lee. My question would be, if you took age out of the equation, as I understood the record, there was another applicant that was described as the most qualified, who was, I think, 60 years old. And would you have to present evidence that your client would have received the job as opposed to the one that, based on qualifications, was the most qualified if you remove age from the consideration?
It cannot be said as a matter of law that if you remove Jefferson Lee from the equation, the 23-year-old, that the panel would have chosen someone other than Tammy Bandy. And let me get to the very person that you're talking about, Judge Quattlebaum. You're talking about the woman, the 62-year-old woman named Paschal, or Paschal. That's who you're talking about when you mention that person. Here's what the evidence of concerning her is. Wendy Delano said concerning that person, because what the city says is, well, if we didn't hire Jefferson Lee, we would have hired Ms. Paschal, for example, the 62-year-old. But here's what Wendy Delano said concerning that. Wendy Delano says, and this is in the joint appendix at page 214, line 32, she said that one of the other candidates, talking about this Ms. Paschal, should have been given the job, but she didn't make the cut, quote, because I felt she would be overpowering the dynamic we currently have, whatever that means, entirely subjective. And so she sort of eliminated herself in the process. So according to Wendy Delano, she undercuts the very argument that the city is making. Wendy Delano would have never hired, or the panel never would have hired this Jennifer Paschal in the first place, and that's the woman that you're talking about. She's in her 60s, so that answers that question. But that also gets me to the ranking question, which you may ask me at some point, because was there a ranking in this case of the candidates that resulted in a certain positioning of the candidates? And the answer to that is no. There's evidence that there was not a ranking. Hank Luton says, quote, and I asked him, was there a ranking? He said, quote, I don't think so. I can't remember. I thought I only gave my top two. I don't think they were ranked 1 to 6. Now, there were only 4, but he's talking about 1 to 6. So this ranking, again, didn't really exist. And even Wendy Delano said, when I asked were the candidates ranked, she said, quote, not formally, but after the interview, we did rank them informally just to try to get a feel for who we felt were the best candidates. So there wasn't really a ranking, but even if there were, that ranking is the product of a biased panel who was biased against Ms. Bandy on account of her age. Now, I think I've been looking at this case wrong, frankly, from the beginning, as I have looked at this case as that Wendy Delano did not want a woman about her age serving in that booking coordinator position, that she preferred younger men because she'd hired 2. Chris Fisher was 38, Hank Luton 39. I may have flipped the ages. But looking at it now, I'm thinking, well, maybe instead it's that Hank Luton and Chris Fisher wanted somebody younger working with them, somebody more their age, so they wanted the 23-year-old who was closer in age to them, and not, frankly and bluntly, some gray-haired grandmotherly woman, which is exactly what Tammy Bandy is. So those reasons, Judge Quattlebaum, are undercut one by one, and we're left with, is there evidence that from which a jury could find that age was a but-for or the but-for cause of the action in this case? And I frankly submit that there is. I think as to the rest of the points that I make, if a lawyer has 20 minutes, they think they have to use 20 minutes. I think that I don't need to say anything further. I'll answer any questions you may have. I'll be happy to. But
I have a question.
Yes, sir.
You didn't mention in your opening brief that you were challenging the constructive discharge claim. Are you waiving that?
Yes, sir.
Okay.
The judge ruled against us on that. I think there's not enough evidence to go forward on that. We're not arguing that in this appeal. Yes, sir.
Thank you.
So I'll stand down there.
Thank you, counsel.
Good morning. Jeremy Carroll, on behalf of the appellee defendant, City of Salem. May it please the court. Judge Quattlebaum, to your question, if you took age out, and I think that touches on Justice Gorsuch's question or his analysis in Bostock, where he says if you move out a factor, let's remove a criteria and let's see if it changes the outcome. And respectfully, if Mr. Lee and Miss Bandy were the same age, the outcome would not have changed in this instance, because the qualifications are such that Mr. Lee clearly had the superior qualifications for this position. And it's important to reiterate, and we did this on brief, that it is the perception of the employer that is at play here. We don't look at it in hindsight. We don't play super personnel committee. We look at the perception of the employer and we determine if the perception was reasonable based on the record.
What do we do with the fact that Mr. Lee applied for this very job, not just other jobs, and was not hired, and as I recall, not hired because his qualifications were inadequate?
Well, there is a grading system on their scale, and he was given a 1 when he previously applied, just as Ms. Bandy was given this time when she applied. And that just meant he didn't have some of the bare qualifications. He did spend that interim year, that intervening year, which is the exact same year when Ms. Bandy was working at the Civic Center. So Ms. Bandy would say it made her more qualified to apply for the booking coordinator position. Similarly, it made Mr. Lee more qualified to apply for the booking coordination.
He worked as an athletic director during that time?
He did, as an assistant athletic director at a local high school where he was working on booking, scheduling events, hotel bookings, travel bookings, doing some event planning. I think the event planning was Parks and Recreation, I'm sorry, Your Honor, before that. But yeah, so that's what he did in that year. But what's also interesting about that argument, Mr. Grimes says, well, it's the panel, it's the panel, it's the panel. Well, the panel that passed over Mr. Lee twice, once in February of 2018, consisted of Ms. Delano and Mr. Luton. The panel that passed over Mr. Lee for a different position, I think it was an events coordinator position, in November of 2018, consisted of Ms. Delano and Mr. Luton. They both twice passed over Mr. Lee. Similarly, those two same individuals were on the panel that hired Ms. Bandy. When you look at Proud versus Stone, I think the city benefits from a inference of non-discrimination when those members of the panel were the same who made the Bandy hiring decision and elected not to hire Mr. Lee on at least 2 occasions.
How old was the person that was hired on those 2 occasions?
One of them, I believe, was when Mr. Fisher was hired, 39. The other, I don't recall, Your Honor.
But, I mean, you see why that would matter, right? Like if they're hiring other young people, that doesn't really help you much.
Sure, and I get that point, Your Honor, but I think it's worth pointing out, again, those 2 individuals did hire Miss Bandy, who was 52, and Miss Delano was 51. There's a further inference when the decision maker, of course our position is that Ms. Delano was the decision maker, is in that same protected class. So you're going to, respectfully, there's an inference that she's not discriminating against someone from her own protected class. And on the rankings, a point that Mr. Grimes brought up, and in response to your question, Judge Quattlebaum, the rankings, Ms. Pascal was 3rd, Ms. Bandy was 4th. There were 6 candidates. There were 2 behind them. One was 23 and one was 40. But Ms. Loving was the 2nd ranked candidate, and she was 44 years old. And Mr. Fisher ranked them that way, all 3. It's clear from the record. Ms. Delano ranked them that way, all 3. And the conflict that Mr. Grimes is trying to strike up is Mr. Luton may have just ranked the first 2, Mr. Lee and then Ms. Loving, without actually saying Pascal was 3rd. He did say, I think maybe I only did 2. But there's no question that the other 2 individuals, and there's no evidence that Mr. Fisher or Ms. Delano were ever motivated by age, those 2 clearly ranked the candidates in that order, and that is why we agree with Judge Urbanski at the district court level that she could not have proved, Ms. Bandy could not have proved that she would have been hired.
Loving's age?
44, Your Honor. And in this type of case, Your Honor, obviously, we look at Westmoreland. That is the kind of the leading case in the circuit on this type of matter. And there, the court made it clear that what you have to do is both attack